Good morning all, and thank you so much for joining us. We are delighted to see so many of you joining the session today, and we hope that this will be a useful, quick review, whistle-stop tour of some important points, largely to do with practice and procedure, which affect all of you who practice in public law. My name, as I said a mere 2 minutes ago, but why not say it again, is Fiona Scolding, and I'm chairing the session today. I'm joined by my two esteemed colleagues in chambers, Miranda Butler and Charles Bishop, who I will formally introduce in a moment. Without any further ado, I shall introduce my two colleagues. Miranda Butler is a member here at Landmark who specialises in particular in migrant rights and refugee cases and has a particular interest and focus on issues relating to trafficking. She has been involved in the PRCBC case, which she shall be speaking about this morning, which is particularly important about the use of extra or parliamentary materials in the context of claims for judicial review. Charles Bishop is again another member of Chambers. He has a wide-ranging public law practice. Over the course of the past year, he has done cases as varied as a case on behalf of the 3 million in respect of EU settlement rights post-Brexit. He is currently undertaking a case about river pollution and enforcement or failure to enforce those who contravene river pollution rules. And he was also involved on behalf of the Secretary of State for Health and Social Care in the Gardner case, which was all about COVID and the decision to discharge people from hospital back to care homes in March 2020. So both our speakers today have extensive experience in public law and will be providing you with what hopes to be a hot topic update of what has happened in that time. So I pass now over to Miranda. Good morning, Miranda.
Good morning, Fiona. Thank you very much for that kind introduction. As Fiona has indicated, I'm going to be talking today about a few points for practice. Whereas 2021 brought us some wide-ranging and structural judgments on issues such as how to approach policy challenges, 2022 has been somewhat narrower, and our talk reflects that, I believe. It's interesting to note some of the data that's come out recently about the number of cases on which the Supreme Court has been granting permission in the last year. It is clearly taking a somewhat more restricted attitude, granting permission on fewer cases and dismissing more cases than has been the case previously. But against that backdrop, let me start by talking about a Supreme Court case that was granted permission, but unfortunately was not successful. This is the case of PRCBC that Fiona just mentioned. That is an acronym for the Project for the Registration of Children as British Citizens. It was brought by that charity and also by an individual child called O. The fundamental takeaway point here, before we get into the details of the case, is the Supreme Court's indication that we should be moving away from reliance on pre-legislative materials in public law cases. What do I mean when I'm talking about pre-legislative materials? I mean the full gamut of Hansard reports, explanatory notes, Law Commission reports, reports of Royal Commissions, advisory committees, and government white papers. As I'll come on to discuss, the court treats these slightly differently in sort of three broad different categories, but those materials compendiously, their use is now being discouraged by the highest court. So this was a challenge to the fee of over £1,000 that is charged to children seeking to register as British. The British Nationality Act sets out a series of entitlements for children to register as British, in particular where they have lived in the UK for 10 years from childhood. In the 80s, when that act was passed, there was no fee for the application, but subsequently that has been made subject to a high and rising fee. We brought a challenge on the basis that the fee was ultra vires because the fee had been set at such a level that it cut down an important statutory right and thereby excluded many children from citizenship. And in support of that claim, I, as one of the council team, argued in reliance on pre-legislative and Hansard materials, showing that in passing the 1981 Act, Parliament intended this to be a right that children could access that would not be contingent on its affordability or on individuals' ability to pay. The court did not accept our reliance on those materials and refused to consider them in this case. I've here characterised this as a turn to textualism, a more narrow literal reading of the words of the statute rather than a more generous inclusive reading that would include consideration of these materials. Lord Hodge certainly did not suggest that these materials could never be looked at. However, he emphasised strongly that the starting point for the court and also for us as practitioners must be to look at the language of the statutory provision in the context of the Act as a whole. In this case, there were, in fact, a number of relevant statutes and statutory instruments that the court looked at in some detail. And Lord Hodge explained that often that will also be the end point for the analysis. If the legislation is clear and can be understood in its own terms, then very often it's simply unnecessary to go beyond that. And he emphasised that pre-legislative materials must play a secondary role in that analysis. However, looking at the way in which he distinguishes between the different pre-legislative materials, he does acknowledge that explanatory notes, which are prepared under the authority of Parliament, can cast a light on the meaning of the statutory provisions, whereas other external aids, such as Law Commission reports or white papers, might be able to identify the mischief that the Act seeks to cure and the purpose of the Act, and therefore may be relevant in assisting a court to understand its meaning and purpose. Separately, when it comes to using Hansard debates, Lord Hodge emphasised that we need to demonstrate that the criteria in Pepper and Hart are met before reference is made to Hansard. And I'm sure everybody here has the rule in Pepper and Hart off the top of their heads, but in case anyone doesn't on a grey Thursday morning, the rule in Pepper and Hart requires us to ask whether a statutory provision is clear, unambiguous, and does not lead to absurdity. And if it is indeed clear, unambiguous, and does not lead to absurdity, then it should simply be applied rather than looking to Hansard to further interrogate it. So this is a strong judicial indication that we should not be starting or leading with the statutory context in which an act was passed, but rather with the language of the text itself. And we will need to show good reason to ask the court to look into its history, to look into pre-legislative materials. There was quite a striking example in this case of how far one might end up departing from the rule in Pepper and Hart if it's not enforced like this, because whilst it didn't arise in the Supreme Court, in the Court of Appeal, the Home Office had sought to rely on Hansard debates as demonstrating that she had discharged her obligation under Section 55 of the Border Citizenship and Immigration Act to consider and treat as a primary consideration the best interests of affected children. This is, of course, a significant, or if it had been upheld, it was not upheld by the Court of Appeal, would have amounted to a significant incursion into the rule in Pepper and Hart, which allowed not only consideration of parliamentary debate, but even reliance upon it as evidencing discharge of statutory duties. We should note that Lord Hodge's judgment is perhaps glossed rather than in any way disagreed with in the concurring judgment of Lady Arden. She seeks to emphasise in her judgment in PRCBC that pre-legislative material may reveal ambiguity which is otherwise not evident on the face of the legislation, and that in those cases it may go to the court's reading of the legislation itself where it appears clear. So practitioners certainly should be looking at these materials, but should be doing so mindful that they have a significant burden to discharge before relying on them in court. However, please do not take anything that I've just said as encouragement to make extensive use of pre-legislative materials. In the oral hearing in the case of Coughlan versus the Cabinet Office, Lord Reid may I say rather grumpily interrupted counsel and characterised PRCBC's whole gist as encouraging practitioners to waste the court's time a great deal less in looking at background material. So I think that we should take the President's direction on its face and only be relying on these materials where we have very good reason to do so. So moving on to quite a practical issue, from the grandeur of the Supreme Court to our everyday experience of taking witness statements. This is an issue I have seen a lot in my own practice because most of my clients are individuals who don't speak English as their first language. I'm sure I don't need to remind anyone attending of the provisions in Practice Direction 32 of the CPR, which emphasises that witness statements must, if practicable, be in the witness's own words, and in any event must be drafted in their own language. And also that foreign language witness statements must be filed in the original language together with a certified translation, and the original statement must be signed by a translator, or excuse me, by the translator being used. This guidance, unfortunately, is quite often overlooked, and it was an issue that arose admittedly not in the administrative court, but rather in the Chancery Division in the case of Bahia, in which the court noted that a witness did not understand many of the words in his English statement. He spoke both English and Punjabi, but English was not his first language, and the court criticised the witness statement for being overly lawyered, but recognised that his solicitors couldn't be criticised for having prepared them in English. There wasn't any suggestion in this case that the preparation of the statements in English or the use of words that the witness didn't fully understand had amounted to the witness being led, or this not being properly his evidence. But this is a very useful reminder of practitioners at all levels, including public law practitioners such as ourselves, as to how we should approach these cases. The following is how I approach cases. If anyone has a different approach, I'll be very interested to hear it. So realistically, because we work in English, we are highly likely to need to prepare a first draft witness statement in English. However, once that draft has reached a degree of finalisation, you should make sure that a full finalised version is prepared in your client's own language or in the relevant witness's own language. That should then be signed both by the witness and by the translator. That statement can be filed, but it must be filed alongside a certified English translation of the original. And unfortunately, in many of the cases that I deal with, we have hours, we're lucky often if we have days, in order to bring proceedings for clients who may be street homeless, who may be in detention, and where the preparation of detailed witness statements is challenging, notwithstanding the additional barriers posed by translation and by the procedural requirements. So what I've been compelled to do in a number of cases is to depart from these rules in the interest of time, to file an approved statement in English, and to confirm in a witness statement from my solicitor that the relevant rules will be complied with as soon as possible, and then to follow up at our earliest opportunities. I appreciate that the rules are phrased in mandatory terms, and we should be mindful of that. It's not my practice to go around encouraging people to depart from the rules, but where it's simply not practicable to do so, I think that is a realistic workaround. Moving on to another procedural issue that we've seen emphasised repeatedly this year, in particular by Mr. Justice Fordham, is the issue of venue. And my takeaway point here is the very first one: think before you issue in London. I know that I tend to default to thinking everything happens in London, and the Administrative Court will certainly not like that attitude in me or in anyone else. I'm sure you'll all be aware of the general expectation that's set out in the CPR that proceedings will be determined in the region to which the claim has the closest connection. Usually that will be where your client is living, where their offices are based, if they're a corporate client. However, the rules do acknowledge a number of exceptions to this. I have listed some of these on the slide. They involve travel difficulties and expense, the public interest in a case being dealt with in one area rather than another, delay or a very heavy workload in a particular jurisdiction where the parties' legal representatives are based, and perhaps most significantly, to my mind, whether there are already similar proceedings that are in train at a specific venue. I would have thought it would only be appropriate to seek to rely on that exception if you were making a positive application to join or perhaps stay your claim behind those proceedings. In Subramaniam, Mr. Justice Fordham considered the case of a claimant who was detained in Doncaster, but who had issued a JR in London. Mr. Justice Fordham transferred the case from London to Leeds and criticised the claimant and his representatives for having caused delay in what were otherwise quite urgent proceedings as a result of having chosen the wrong venue. The claimant's legal representatives had sought to argue that London was appropriate because it would cause additional travel costs to have to travel to Leeds for any hearing or other in-person attendance. But Mr. Justice Fordham considered that that wasn't determinative. Of course, travel costs should generally be covered by legal aid in cases such as this, and dismissed as speculative the prospect that the claimant might be moved to an immigration removal centre based in London. So essentially, I think this suggests that even in cases where you might potentially fall within the exceptions set out in the rules, you really should be seeking to issue outside of London if that is where your client is based. And you'll have to make out a very good case for issuing, particularly in London, if that's not where your client is. And if we go back to those exceptions, you can probably see that a number of those can readily be overcome, especially in days when hearings can and often do occur remotely. I've given everyone a little reminder here of the relevant administrative court offices that we should be using, depending on the relevant area in question. Another warning for practitioners here. I have a feeling that everyone's WhatsApp lit up when this case was handed down. It involved an accidental breach of an embargo on a judgment that had not yet been handed down by the Court of Appeal. The counsel in the case sent the draft judgment whilst under embargo to their clerks in order to assist with marketing. And very unfortunately, their chambers ended up publishing the judgment on their website before it had been handed down. In this case, the Master Rolls reiterated the mandatory terms of Practice Direction 40E, making clear what, of course, you already know, which is that these judgments are subject to an embargo and must not be publicised or disseminated in any way before they are formally handed down by the court. There's a number of specific practice points here, and this is not just relevant to barristers and barristers' chambers. This is equally relevant to all legal practitioners, and I have no doubt that many of those attending today will already have implemented a number of these changes in your own firms and offices. The MR emphasised that it's not appropriate for chambers staff to have access to a draft judgment or even to be given a summary of its contents before it is handed down. In particular, it's not appropriate or legitimate for clerks to be involved in marketing endeavours for a draft judgment prior to the embargo being lifted when the judgment is handed down. So marketing purposes should simply not arise prior to the hand down of judgment. There's no reason why we as practitioners cannot start drafting press releases if we're desperately keen to, but that is not something that we should be sharing with third parties. Perhaps quite specifically here, the MR considered that it should suffice for one named clerk, or potentially in solicitors' offices, one might imagine a paralegal or a secretary, to provide the link between the court and the barristers or other legal practitioners where relevant. I do raise a question as to how practical that is, given the large staff that many chambers and firms work with today. But it's certainly something that we should be seeking to create policies to implement and protect. And we need to be mindful of this when we are handling embargo judgments ourselves. The MR emphasised that there should also be proper precautions and double checks in place to ensure that these kind of errors are identified. So if you're about to publish about a new case on your website, you need to have some kind of policy in place to make sure that it is certainly already in the public domain. One might have thought that an automatic check that something is already up on the internet and available in the public domain would be a very easy way of avoiding that issue. The MR unsurprisingly referred to the possibility of contempt proceedings in this case. He was satisfied that in this case it was a simple accident and wholly unintentional. But of course, we are mindful of previous intentional breaches of embargo. And the MR was clear that in future contempt proceedings might be brought in appropriate cases. So I'm going to finish by touching briefly on the Rwanda litigation. I'm sure that everyone is aware of the lengthy judgment that was handed down shortly before Christmas, in which the divisional court rejected on all grounds the claims brought by a number of individuals and organisations challenging the scheme whereby asylum seekers will be sent to Rwanda for their claims to be processed. I don't intend to go into detail on the substance of that judgment here, because that would merit an entire hour's seminar just by itself. However, there are some interesting wider practice points for us to be aware of. In this case, the court had combined a very large number of claims and had two separate hearings, but issued a single judgment regarding them all compendiously. This was a first of kind, a world first scheme that was being considered for the first time, with a large number, as I say, of individuals, but also of public interest groups challenging it. And so, unsurprisingly, it was factually, procedurally, and legally both complex and voluminous. And as you can see in the quote that I've given you here, the court was extremely critical of the parties for their pleadings not being a model of good practice. They particularly emphasised the length of the pleadings and the fact that some of the pleadings were hundreds of pages long. As you'll see here, the criticism extends to calling the documents meandering and repetitive. And the court emphasised that it had become very easy to miss the wood for the trees. I will leave it to other wiser heads to opine on whether that's reflected in the judgment or not. But quite simply, takeaway here should be, as always, that it is better to be clear and concise and say less rather than to say more. And so I'm going to re-emphasize the page numbers that we should be using. Statements of facts and grounds shall not be more than 40 pages. Whilst you can have permission to exceed that, I do not consider that it is necessary. In the most complicated cases I've ever had to do, I've never needed more than 40 pages. If there's a complex factual background, you can append a chronology. If there are other judgments or materials you want to refer to, being mindful, of course, of pre-legislative materials, you can have that in the bundle and cross-refer. The more concisely and tautly you can frame your case, the more persuasive it will be. Similarly, summary grounds shouldn't be more than 30 pages, and detailed grounds shouldn't be more than 40, and skeleton arguments shouldn't be more than 25 pages. That's one that I do struggle with, I will acknowledge. But once again, chronologies, summaries, bullet points, and cross-reference are very much our friends here. One very final point before I finish. I just wanted to note that the admin court guide that came out this year is a bit more generous to permission stage replies. In 2021, it emphasised that permission stage replies are rarely necessary and are not encouraged. Whereas here, whilst it does say that you should only file a reply if essential, it's much more permissive, and particularly where it is concise and confined to true reply points. I find permission stage replies very helpful and clarifying, and if they are brief and to the point and genuinely only reply, I think they genuinely do assist the judge. I'm now going to hand over to Charlie.
Well, thank you very much, Miranda, for that, and to Fiona for the introduction. Thank you all very much for joining us. It's really great to see so many of you. I suppose it's probably not too late to say Happy New Year to you all. I'm going to talk about 4 topics today. Going to start with standing, then look at witness evidence, quite a few issues in witness evidence, then want to look at service and time limits, and then just a very short point which sort of piggybacks on the point that Miranda just referred to about procedural rigour. But I think as a sort of overarching point, I just wanted to start by noting that perhaps one of the biggest trends we've seen in the past year has been on courts and defendants taking more robust positions on procedural points and points of practice on areas that perhaps previously had been considered to be quite settled. And there's now been a kind of renaissance in judicial review procedure that has triggered some reconsideration of some of those principles in the past year. And I think that's been particularly notable in relation to standing and the heightened scrutiny of standing of claimants, particularly in public interest or strategic litigation challenges. Just as a reminder, claimants have to show they have a sufficient interest in the matter to which a claim for judicial review relates. And that's considered to be the same as the directly affected test in Scotland. What we've been seeing is that standing is now far more than just a procedural or jurisdictional step. This has long been recognised since the 1980s in the National Federation Self-Employed and Small Businesses case, but it's now considered in quite a lot of detail in judgments. And this trend really commenced, I would think, this year, last year, forgive me, in the Runnymede Trust and Good Law Project case against Prime Minister. And this was a challenge to decisions to appoint to senior positions certain individuals on test and trace and on the vaccine task force during the COVID pandemic. The claim did succeed in part on public sector equality duty ground, but the court was alive to look at the standing of both the claimants and ruled that Good Law Project did not have standing at all to bring any of the grounds of claim, and Runnymede Trust only had standing to bring one ground, which was the public sector equality ground. It did not have standing to bring a claim in bias or in indirect discrimination. And the reasons were because other individuals who were not appointed to the position could have brought a claim and they did not. Individuals who had the relevant protected characteristic against which it was alleged there was discrimination could also have brought a claim, so the court said. And the court also said that a more appropriate forum would have been the employment tribunal. But I think what's particularly important about this case, because all those factors are quite specific to an employment and appointments process, what was particularly notable in the Runnymede Trust judgment was the turn towards the idea that NGOs bringing claims need to have a much more direct link to the substance of the matter which the claim concerns. And the court surveyed some of the cases which the claimants had relied on in that case to support the idea that they had standing in the case. And what the court said was that in all of those cases, the NGO concerned had a particular interest and in a sense was representative of an identifiable group in society which was affected by that particular decision. And the court said that Good Law Project couldn't suffice to refer to its articles of association, which had established the idea that it was established to promote, in broad terms, good governance. That couldn't be enough to confer on it standing for the purposes of engaging the court's jurisdiction in judicial review to look at decisions of public authorities. Now, we can see this kind of more clearly perhaps in the Rwanda litigation, which Miranda just referred to. As she mentioned, there were a large number of claimants, but there were also claims specifically brought by 3 organizations. The first was the public, with the PCSU, which is Union of Civil Servants. And the court looked at this through 3 different types of standing, which were set out by an academic, Peter Kane. And the first type of this is called associational standing, which is typified by an organization suing on behalf of its members. And the court said that that happens when generally the members would themselves have had standing. And so this is just an association of those members. The court rejected the idea that public sector union members could have standing in respect of individuals, that it's individual decision makers could have standing in respect of the decisions that they are asked to implement on a day-to-day basis. And kind of behind the argument of PCSU was that this affected the well-being of the members who were being asked to implement the Rwanda litigation. The court rejected the idea that those decision makers could have standing themselves. And then in relation to 2 charities, Detention Action and Care for Calais, they had suggested that they had surrogate standing. So this is the idea that they're representing interests of others who are not themselves well placed to bring the action. And the paradigm example of that, as is referred to in a number of the other cases, is Child Poverty Action Group, who's bringing a case on behalf of individuals who may not be able to bring the case themselves. But the problem in this case was that there were individuals who did actually bring claims themselves in relation to the Rwanda litigation, individuals who were directly affected by it, in that they were going to be subject to removal to Rwanda. What Detention Action and Care for Calais argued was that, well, there's a concern that what's going to happen is we're going to issue the claim and then their removal direction is going to be cancelled. So the claim is going to become academic. And so we won't be able to continue to pursue the claim. The court said that that wouldn't be enough to confer standing on Detention Action and Care for Calais. I think that particular point is going to have probably more lasting implications for other cases where organisations are concerned about decisions being rendered academic in the community care context, or in any other context where the defendant concedes, but you're trying to demonstrate there's some wider systemic issue. It's going to be more difficult to establish standing as a surrogate standing charity in those situations. Just of note, as another Good Law Project case, I think notable here because the court decided not to look at standing because merits weren't made out in the first place. So this was a case that went to the Court of Appeal. It started in the divisional court alongside another organisation called All the Citizens. It was a challenge to the government's use of electronic communications through private communication methods like WhatsApp. And it was a challenge to various policies around that, the implementation of those policies. Only Good Law Project takes this case to the Court of Appeal. All the Citizens did not take it to the Court of Appeal. The court dismissed the appeal. The case is a very interesting case on internal administrative guidance or policy generally, which I think will have quite significant implications on that substantive area of practice. But I wanted to just note what's interesting is that courts are not always descending into scrutiny of standing, where they've analysed the merits and they've concluded there are no merits. In certain situations, they are willing to just move on and leave it there. But there was an opposite approach in another Good Law Project case, which was a challenge to contracts awarded to Abingdon Health to develop lateral flow tests during the pandemic. The Secretary of State disputed Good Law Project standing, and Ms. Justice Waxman gave a very detailed overview of the general approach to standing and looked at it on a ground-by-ground basis and in a very lengthy judgment, not just on standing, but on procurement generally. Ultimately, the conclusion was there was no standing on any of the grounds, although that was ultimately an academic issue because the grounds weren't made out anyway. But I think what's particularly useful from this judgment is this overview of the various factors that might be at play when the court will be looking at whether or not an individual claimant has standing. So there's the merits of the underlying claims. If they are of more merit, that's going to lend itself more strongly to their being standing. The particular legislative or other context of the claim being made. So that's going to be about who might be the natural claimant. That's what the judgment talks about. And in the procurement context, it's about who might be the economic operators who might be relevant here. Doesn't mean that a person other than an economic operator might not be able to bring a procurement challenge, but they will more likely be the right challenger. The other factor is how, if at all, the claimant might be affected by the unlawfulness alleged. If you're not actually going to be affected at all, then that suggests that you don't have sufficient interest in the claim. The gravity of the allegations or the findings being made, I think that really speaks for itself. Who the other possible claimants might be. And I think that's probably one of the most determining factors in this, because we saw in the other cases I just looked at, that was something that really prevented standing in some of the cases, because the court suggested there might be other people better placed to bring the case. And then, of course, there's the position of the actual claimant, what it is that they say they have, that means that they are genuinely interested in the case. So the next big topic I want to address is witness evidence. So I've got 4 subtopics within this. I'm personally encountering issues with witness evidence a lot in my practice. I considered that witness evidence can be quite underappreciated. I think it can often make or break a case, but often I think the rules are not entirely understood, and generally there has been increased formalism in this area by the courts. And I want to start with the Gardner case that Fiona referred to in the introduction. This is a case I did last year. I was part of the team for Department for Health and Public Health England. This was a challenge to various policies about COVID and care homes at the start of the pandemic. And in this case, there were quite lengthy witness statements from both the claimants and the defendants to do with transmission of coronavirus, asymptomatic transmission, etc., testing, history of testing in the UK, self-isolation, PPE, and so on. There was no permission that had been given to file expert evidence under Part 35, and generally opinion evidence is only admissible if given by an expert with permission to file expert evidence when there's been an application under Part 35. There are strict limits on when expert evidence is admissible in judicial review. And the Law Society case from a few years ago is probably the best used example of setting out when expert evidence is generally permissible. In Gardner, the court in an interlocutory stage was concerned about various references to opinion in some of the claimant's witness statements. And there was then a hearing as to whether or not that was admissible, and the court rejected the idea that expert evidence could be given outside of Part 35, such as where a witness who is appropriately qualified as an expert, although isn't claiming to be an expert in terms of Part 35, is giving evidence of fact. So they're saying, this report was published, this thing happened in care homes at this time, but adds expressions of opinion at the same time as doing so. So this report was published, and this should have happened in government. So, but the court did say that there could be a limited allowance for experts to assist with evidence in human rights cases. In Gardner, it was an Article 2 case. And that could be to demonstrate material which, with proper inquiry, a defendant could have had before them in order to take into account in terms of giving effect to the human rights of the individuals. But that didn't mean that a claimant can refer to evidence which was not before the decision maker, because it came about after the decisions had taken place, which might have cast light on whether or not those decisions were right in the first place. And I think what's interesting in Gardner is this line between opinion and fact that emerges. So the court summarizes it as evidence is admissible to show what happened in care homes. That would be evidence of fact. But expressions of view as to what should or should not have happened would be evidence of opinion. And often I think you see those two alliing themselves in witness statements. And there's a tendency to introduce opinion, not necessarily by an expert, but sometimes by an expert who isn't actually seeking to be admitted as an expert statement under Part 35. There was further exploration of this issue in a challenge to the Home Office's pushbacks policy in the Channel. That policy was withdrawn by the government prior to the substantive hearing in this case, which was brought by the Civil Service Union that I referred to earlier in the Rwanda litigation. But there was an interlocutory judgment about the admission of 2 experts on maritime search and rescue. The court ruled that those reports were not admissible, and in doing so reiterated that there is a narrow basis on which expert evidence may be admissible in human rights cases, as in the Gardner case. In other words, it can't extend to post-decision evidence. It could only refer to pre-decision evidence. And generally the court kind of summarized how to approach when expert evidence would be reasonably required to resolve the proceedings in a judicial review. First, you have to identify the issues which the expert evidence is said to be relevant to, and then you have to evaluate whether the expert evidence is reasonably required to resolve those issues. And the court referred to another case which has set out that what reasonably required means in more detail. But the court said that in some instances, expert evidence may be of potential relevance to an issue in the case, but actually there might already be other evidence that's already there, which helps to resolve the issue anyway. And so the expert evidence is not actually reasonably required in order to resolve the issue, and so it doesn't need to be admitted. I want to go back to Gardner now, because there's another theme that emerged on witness evidence from that. And this is perhaps more common, I find, in practice, which is witness statements that include passages that are neither evidence of fact nor evidence of opinion, but are more in the nature of argument or comments, or you might say submission as well, or describing actions as appropriate or proportionate. Generally, those comments shouldn't be in witness statements. The court in Gardner followed a decision in the Technology and Construction Court in a Good Law Project procurement challenge to give such comments little weight. But generally, the lesson from this is to just stick to facts in witness statements or opinion in expert evidence. Leave submissions to submissions. If there's a statement in a witness statement that could have been given in the pleadings, then it should go in the pleadings. It doesn't need to go in the witness statement. It's not going to add anything coming from the mouth of a witness, in most instances anyway. Just to flag also, there is some material in Gardner about inclusion of references to parliamentary material, but Miranda has dealt with that in relation to the PRCBC case. Another topic on witness evidence is about the use of what's called corporate witness statements by defendants. And this is where a defendant is using evidence from a variety of different officials within a department. This emerged in the case of challenging government use of private electronic communications that I mentioned earlier. And the Good Law Project objected to some of the government witness statements, and they said that, well, you need to say where this information has come from. You can't just have a corporate statement which has lots and lots of people feeding into it, but only one person is actually signing it. But the court said that actually in judicial review, a corporate witness statement is a convenient mechanism to satisfy the duty of candor, because it puts all the relevant material to the court. Obviously, you have to identify the source of matters or information of belief that are not within the witness's own knowledge, but that doesn't mean that every individual has to be separately identified. And actually, it may be sufficient just to provide a kind of general overview of how this witness statement was compiled, how it was prepared, rather than identify each individual. And it will really depend on the context. So in some cases, that this might actually be a better way of presenting the evidence than having lots of individual witness statements. That, of course, isn't going to apply, however, if you've got a specific dispute of fact, and that's material to an issue in judicial review proceedings. So an issue, a dispute of fact, in which it's important to know who actually is saying that this happened. There was some similar comments on corporate witness statements in Gardner. Generally, this all goes to the weight that can be attached to a witness statement and really about making the case easier for a court. I don't think that corporate witness statements necessarily need to be solely the purview of defendants. I think in appropriate cases, a claimant might also be able to bring such a case where they are appropriately identifying where the information is coming from, if they're pulling lots of sources of information to demonstrate how something is operating in practice. And just quick point about ex post facto evidence. So this is evidence which is given after a decision has been taken. There was an interesting case in the environmental context just at the end of last year in a challenge to a planning permission, and there was concern that the permission for a cattle shed would lead to pollution of the River Wye. And the court there admitted a witness statement given by a local authority officer to provide a gloss on reasons that were given in a committee decision by councillors. And the court there expanded on when ex post facto evidence might be admissible. And I would say this probably represents a fairly relaxed approach to such evidence. But I think what's interesting about this more generally is this idea that post-decision evidence can be given in general, and there wouldn't be a concern about that being rolling review, which is something that's been alighted on in other cases, which is this idea that you're constantly having to challenge different decisions all the time. And so the court there says you shouldn't really be referring to information which has arisen after a decision under challenge has been taken, but rather you should refer to material that was actually in the mind of the decision maker or relevant person at the time, and which helps explain how that conclusion was reached. Just the final point is on service and time limits. And there's a case that's in the Court of Appeal. It's now going to the Supreme Court. It's been granted permission, and this was in a good law project case in a challenge to an award of PPE contract during the pandemic. And the Good Law Project solicitors emailed an unsealed claim form to Government Legal Department's designated electronic service address. They also sent it to relevant case handlers who they'd been liaising with at the pre-action stage. They then emailed the sealed claim form once it had been issued to those same case handlers, but they did not email the sealed claim form to the designated address for service at the GLD within the 7 days as required under CPR 54.7. And at the High Court, the judge refused to cure that irregularity under various provisions of the CPR, and therefore the claim was not effective. There was no claim. And that went up to the Court of Appeal, and the Court of Appeal, bearing in mind it's at the appellate stage, and so there's a heightened level in which they will rarely descend into interfering with a case management decision at the High Court. But basically, the Court of Appeal upheld the High Court's decision. But what's I think of note is how the court applied the principles in the civil procedurals in the context of the judicial review. And so the court reiterated the importance of promptness in JR generally, and how good public administration requires finality. Public authorities need to have certainty as to the validity of their decisions and actions. And the court made clear that just because an organization might be a charity or not-for-profit organization campaigning in the public interest, they're still subject to the full force and vigor of the civil procedurals, and the nature or subject matter of a claim can't affect the degree of compliance required. So ultimately there was not allowed to have alternative service under the civil procedurals, not allowed an extension under the civil procedurals either. There's a rather notably robust dissent from Lord Justice Phillips, who says that form really has triumphed over substance and litigation has become a game of forfeits if service is not to be validated retrospectively in such circumstances. This was in the context in which there was, he said, not one iota of actual detriment in the invalid notification of the claim form. So I think we need to watch this space, see what the Supreme Court does with this. It's interesting that they've granted permission in the first place. It does strike me as rather a harsh judgment. So it will be interesting to see what happens to it going down the line, because it had the effect of meaning that the claim could not be brought at all, notwithstanding that the Government Legal Department, relevant individuals were fully aware that the claim was being brought. Just a quick point on this as well. There was a rather unfortunate error in a proposed JR of a development consent for the Sizewell C nuclear power station, where the claim was brought just one day after the deadline, but obviously had the effect of meaning the claim couldn't be brought at all because of limitation. And I think the lesson to be learned from this is just, as much as possible, try and bring cases at least a day early, so that if there has been some error in calculating the time limit, it doesn't have this effect. I have huge sympathy for the lawyers in this, as no one wants to get this wrong. And I would just note, obviously, that challenges in planning cases have a much shorter deadline of only 6 weeks. It wouldn't be quite so tight in other cases. And just finally, a really quick point, which kind of piggybacks on Miranda's point about procedural rigour right at the end of her presentation. In the challenge to the electronic communications case, the Prime Minister case that I mentioned earlier, right at the end, there was a note from the Court of Appeal there about the importance of identifying a remedy that you're actually seeking in cases. And there's a notable sentence at the end: the fact that a claimant is unable or unwilling to particularize the relief that they seek may be an indication that the claim should not be pursued. And I think perhaps going forward into 2023, being precise and clear is something that we're going to be expected more of by the administrative court as they deal with this year's cases. So thank you very much for listening, and we now have a little bit of time for questions.
Thank you both very much. I mean, personally, I find the case about service exceptionally harsh, given the very short time limits there are in judicial review, and the fact that everyone who actually needed to know did know. But I do recognise that the issue of service in a lot of county court and general civil proceedings, where there are much longer time limits, there are equally strict rules which cause claims to fall. So it may well be the courts were examining that. It's also very interesting that the restrictions on standing have come not exclusively, but quite largely from procurement cases, where historically there has been a reluctance to allow anyone other than the economic operator in. And that's not a recent phenomenon, because there's been various attempts over the years by unions and public interest groups to engage in procurement litigation without much success. So the concern is really that the much stricter approach, which is used in procurement and which was almost seen as idiosyncratic to it, may well now have leaked, if you look at the Rwanda judgment, into wider issues to do with standing, which I think those of us who have been practicing for longer than Miranda and Charles will remember were issues 20 or 30 years ago, but we felt had sort of settled down. The other issue around witness statements is to think about and look at the commercial court and TCC guidance, because there's been a lot of complaints and concerns in those cases about overly lawyered witness statements. And so even though that isn't directly applicable, I think it's good practice for us all to look at those areas, because I think we tend to think of witness statements in judicial review cases as something a bit different to an ordinary witness statement. So this maybe is a salutary lesson for all of us. Now we've got two very interesting questions. The first question is about standing, which is how far do the courts, particularly post-Rwanda, consider that or have to consider the practicability of other people being able to bring claims when they are saying that a surrogate, in effect, that a surrogate organisation can't do so. So Miranda and Charles, what's your view? And then I'll give mine.
Well, I think it would be relevant whether or not it's likely that other claimants can bring that case. But I think that is just one of the factors that go into the mix. I think the question's been expressed in the terms of, do the courts have a duty to consider the practicability of claims? I think that's probably putting it a little bit highly. I think if you present that information to the court, they obviously have to take it into account. But I think it's probably not going to be enough, because actually, as we saw in the Rwanda case, that was a point that was essentially being made, and it unfortunately was disproven in that case, because there were claimants who did actually bring challenges. So it kind of it was a bit stuck there. But you know, at the same time, there's quite an interesting discussion in that procurement GLP case that I mentioned, which is to what extent can you rely on the fact that actually they didn't bring a claim at all, meaning that actually they don't really have interest in the matter, and so maybe no one has an interest in the matter, maybe it doesn't matter. You can kind of tie yourself in logical knots about it. So I think there's no right answer on that one. I don't know if Miranda has any more particular views on it.
I completely agree. I think realistically it's easiest for the court to be robust when they do have a number of claimants, and I think if we look back to the PRCBC case that I was talking about, that was a case in which we both had an institutional litigant, the project, and also an affected individual. There wasn't any real argy-bargy over standing, but I genuinely believe that litigation was run more effectively, and the court had more accurate information in front of it because it had the specialist body about children's registration as British, and also a lived example of how this was working in practice. And I think that meant the full panoply of evidence was there. So I think we should be pushing for both in appropriate cases, whilst recognising that the court may be more resistant to it.
And just to say, I mean, in the CPAG case in the 90s, this was the reason why CPAG brought the case back in the 90s, and the court recognized that as being something that might be relevant to standing. So it is something that is certainly relevant, the courts are aware of it. But I think what's said in the procurement case is that you can take that too far, and actually you should just focus really on this claimant rather than why other claimants have brought it.
And I think you have to think about context is all. In the Rwanda case, they had people, so those issues could be ventilated fully. If you're talking about cases about social security or community care or welfare, you often don't have anyone that can be used, or those people are not able to effectively use the justice system. So I don't think there is going to be a problem continuing to use representative groups in the appropriate case if you can demonstrate that this is the best or most appropriate way in which these issues can be ventilated. I think what the courts are trying to do is stopping what they would perceive as people who only have a limited interest from coming in and trying to deal with things, which then comes on to the next question which somebody's asked, which is about, in the Runnymede Trust case, there was an issue about an NGO having to represent an established group in society. And where did that leave issues around good governance, which affect the whole of society? And you could argue that the entire series of good law cases that they've brought have largely been about matters which impact on all of us, because they're about the way that government makes decisions which have affected or impacted all of us in one way or another. Now, I mean, my view is that it is incredibly difficult to bring good governance claims. But there is nearly always a public interest group which has a particular interest in that. So, for example, if you look back 10 years, we're now on sort of COVID litigation, but if you look back to the cuts litigation, people like the Fawcett Society, for example, brought claims, judicial review claims in respect of Treasury decision-making and cuts to Treasury funding on austerity. The Fawcett Society is a claim which deals with the role of women in society. And in fact, there weren't any issues to do with standing in respect of that case. So I think there is nearly always an organisation that can be produced to deal with those issues. But I suppose what the courts would also say is there are some issues which are not justiciable, and those issues which potentially affect all of us are issues which should be subject to discussion and debate within the parliamentary context, and therefore not be something that the courts should engage with. I don't know whether Charles and Miranda have any different views.
No, I think that's right. And I think the court's not really worked out what it wants to do about this yet. And there's quite a lot of discussion within the GLP series of cases, looking back at other GLP cases and saying, well, why is this one different? Why do they have standing here and not here? But I think I'll just go back to, there's a comment, I think it's in the AXA case that Lord Reed makes, which is that there might genuinely be some decisions which affect literally everyone, and in which case actually probably anyone could bring a case, and maybe the prorogation of Parliament is perhaps a more obvious recent example. Although I query whether, in light of the modern approach to standing, whether that might have been an attempt to say that Gina Miller did not have standing, because actually there are other people in the claim who had greater standing. In other words, the parliamentarians themselves. Maybe that might have been a point that might be taken now, but I can't recall if it was actually taken at that stage or not. But I think this is an area very much in flux, and I think the courts are not sure yet where they want to go with it.
Wise practitioners on big cases would be well advised to make sure that there are a number of different potential litigants, whether individual or institutional, and that way sort of buttress your approach, belt and braces.
Yeah,
absolutely.
Although you do have to be careful about that, because there are cost consequences potentially. So you don't want to have a situation where you have a lot of people who get thrown out at standing on permission, and you then have a lot of cost consequences which fall out from that. So I think there is a balance potential.
I entirely agree.
Cautious than Charles and Miranda are about that, which follows on to another question that we've been asked, which are, what are the cost consequences if an NGO is found not to have standing? Would they be subject to an adverse costs order, even if the JR succeeded on grounds brought by them, e.g. by another claimant? So, views.
I mean, I think it's going to depend on the facts, and I haven't looked at this in detail to see if there's any detailed guidance on this in the court, but my instinct is that you would be liable for the costs of responding to your role in the claim. So if you are in fact indistinguishable from the other claimants, and those claimants got standing and you didn't, then I can't see how realistically a defendant would be able to separate out what costs there were of responding to you but not to the other claimants. In other cases that will be really obvious, but in the Runnymede Trust case, for example, I'm not sure what the costs order was in that case. But the Runnymede Trust was jointly represented by Good Law Project, literally the same counsel, the same solicitors, and they brought the same grounds. So I can't see how there would be an easy way to separate out what the costs were for government of responding just to you.
In any event, whilst of course you want to be wary about any adverse cost consequences, it's most likely that any costs just of the AOS are likely to be very low. I think if you're getting into oral renewal hearings, you'd need to think again.
Yeah, I think context is all. If you're running the claim and you are the main actor, then there are potential cost consequences. If you're sort of bringing up the rear and you're just there to bolster a bit, then the likelihood of there being any additional costs payable dealing with your aspects, or that anybody's going to realistically be able to work it out, because don't forget there are a whole series of rules about costs which says don't make issue-based costs orders, because they're too complicated. Nobody can work out how much time a solicitor might have spent in a letter dealing with that paragraph rather than that. So if you're a cost judge, you do not want issues-based orders. So, it may well be that practically that all goes away or comes out in the wash, unless you are the one who is leading the litigation. There's then a question about admissibility of expert evidence and whether or not there are particular categories of cases, and the example given is state aid, in which such evidence is more likely to be admissible than others. And I think yes, I think things like state aid, I think things where there are highly technical evidence, so for example environmental cases which would rely on some technical understanding. We were talking, the three of us, before the hearing about, for example, if you were doing a river pollution case which involved understanding how people measured sewage in a river or sewage on a beach, and you needed specialist evidence. All of those sorts of factors are well recognised exceptions. And I would say go back to the Law Society and Lord Chancellor case. That sets out a very good set of criteria when you are allowed expert evidence, and see if you can fit into that, one of which is technical evidence, which wouldn't be available to the court in any other way. But Charles has already said you've got the Rwanda case where there was sort of maritime expertise. But I think the problem is we don't know enough about whether it was just, we're going to tell you all about the maritime law duties, or whether it was about, if a bow wave of a ship, a ferry crossing the channel went that far, a dinghy would be automatically turned over, and therefore you would need to get to them within 20 minutes, which would seem to me to be more of a sort of technical thing. Did Charles and Miranda, have I got that horribly wrong?
No, not at all. I was just thinking, both while Charles was talking and while you were, about the large number of age assessment cases I'm doing at the moment. And those are very tricky cases because, of course, there is no expert test for what age someone is. So inevitably, the evidence that you have on both sides is people saying, I met them, they seem to be a child, they don't seem to be a child. And that is fundamentally opinion evidence. But I do think that the takeaway that at least I'm going to take from Charles's talk for those cases is that you need to be as factual and specific as possible and say it is these objectively verifiable aspects of him that lead me to support the view that this person must be a child or that they must not be.
Somebody else has also asked a case about being late and asked the thing which always makes me tighten every aspect, every muscle in my body, which is the position that you cannot issue on the weekly, monthly anniversary of the decision date, i.e. if the decision is 12th of January, the last day for issuing is the 11th of April, or is there a difference between planning procurement cases and the ordinary 3-month rule, which does allow issuing on the monthly anniversary, or did the RSPB get it very wrong? Well, I don't know about planning, but I do know about procurement, and the rules are different in procurement because it's 30 days, and those 30 days, you have to then count back at least 2 days plus 1 because the form has to be served on that point. So in procurement cases, you have to try and get it in within, really towards the end of the 5th week rather than in the 6th week. And there's a lot of procurement cases about that because that is a really difficult thing and people get that wrong all the time.
And just on the planning cases, and this is a specific type of planning challenge. So this is a challenge to a development consent order, which is for nationally significant infrastructure projects. It's about infrastructure projects, and there's a separate regime for that. And section 118 of the Planning Act 2008 actually specifies it in much more detail than you get in other contexts. And it says the claim form has to be filed before the end of the period of 6 weeks, so it's 6 weeks in the planning context, and that the period begins with the day after the day on which the order is published. So that gives you an indication. So it's the end of the period. So you calculate it from that. And I think basically what happened with RSPB is there was just a mistake somewhere along the way. And what's interesting is that the Planning Act was actually amended because of this issue, which emerged quite soon after its inception. So it's unfortunate that it's happened again in this context. What was fortunate was that in RSPB case, another claimant did bring a claim in time, and so the arguments can still be aired, basically.
Yeah, and somebody else has also asked a question that if an individual claimant can be identified, is it any less helpful for an NGO to provide a witness statement or apply to intervene instead of being a claimant? That's a decision dependent on context, but are there any other key considerations aside from costs?
So I think that's a great question. I end up doing this in loads of my cases, and I think that NGOs can add enormous value. The number of cases that I've done that have strategic issues where we have individual claimants, but there is essentially no factual dispute about the strategic issue because you have a panoply of NGOs saying this provision isn't working well, this funding isn't sufficient, whatever it may be. And then that essentially parks that factual dispute instead of having to extrapolate it from your client's circumstances. So yes, I completely agree, it's context specific, but in strategic challenges, I think it's often essential, especially where you don't have an NGO that's really keen to bring the claim, or where there are potentially standing issues. Also, in most of the cases that I do that are strategic, the individual claimants are entitled to legal aid, and so funding is much more straightforward for them than it might be for NGOs. I think the key considerations I might flag up is if you're getting really high up in the judicial hierarchy, the Supreme Court has been very discouraging when it comes to interveners. That's another issue that you see in PRCBC, and that's not the only time that we've seen that issue. So I think you'd want to be judicious about how much you could add value, but there's obviously a distinction between putting in supportive witness statements just as witnesses in strategic litigation, which can then be referred to at any level, as opposed to positively intervening. And I was a judicial assistant at the Supreme Court for a while, and naming absolutely no names, the word vanity intervention was sometimes used, and certainly you want to avoid that. You want to know that you're really adding value, but that's always dangerous, because if you make a really good point, it's quite possible one of the parties will nick it off you, and then it will seem as though you're not adding so much value. So I think interventions are valuable when done well, but I don't pretend they're straightforward.
And
No.
just an interesting example of this was in the Supreme Court in MS Pakistan, where the MS themselves didn't want to take the case to the Court of Appeal. I can't quite remember, but potentially kind of disappeared, unfortunately. But the EWHC had intervened and wanted to take the case up to appeal. And the Supreme Court did allow them permission to take over the conduct of the appeal and continue the case. So I suppose that's something else that you want to factor in, is how much control will you have over the case if you're actually a party to the proceedings, versus if you're only providing a witness statement in support of someone. It's that level of control.
Well, and also, if you're just providing a witness statement and support, you have to think about, am I providing a factual witness statement, or am I providing opinion evidence? And therefore, do I get into the difficulties with expert evidence? I mean, I certainly think a well-timed intervention can be incredibly helpful. And I would encourage NGOs and other organisations to intervene, because whilst I can't say there are no cost consequences, I think they are often limited if what you're doing is supportive the claimant's case, rather than bringing in a whole lot of new issues, which, you know, can be problematic and can lead to cost issues. But I do think that the Supreme Court and the Court of Appeal have got wise to this and are much stricter than they used to be about who comes in, and are not fans of what Miranda has called the vanity intervention. So I think, in a way, you and the other NGOs, if there is some discussion, need to work out which one of you is going to be doing it for what purposes. So there's just one of you, rather than 6 of you all vying for your 15 minutes in the sun, even though, and maybe even all of you going together and doing you know, having kind of one of you saying, we are doing this on behalf of these other organisations. This is the information we would like to put in as a whole, could be something that you could think about in terms of intervention. So there's only one of you intervening, but you are collating and gathering information from a wider variety of sources in the sort of strategic, but this is all in terms of strategic litigation. And last but by no means least, because I think it's just as important, in urgent cases, Miranda, would a further option, rather than the one that you suggested, be to have an interpreter read the statement in the language, in the person's first language, and then say, and then be able to provide a statement saying, I have read it to them in their language and it is true, and to do that on an urgent basis, and then sort of produce the translated version on an ex post facto basis?
It's certainly essential to make sure that in whatever witness statement you're filing, in whatever language you're filing it in, to make clear that it has been understood by the witness and that it's been translated to them in a language that they speak, and to set that out in detail in the statement. So I'd certainly agree that that's the way to do it. If you've got an English statement for a non-English speaker, it should say, this has been translated to me into my native language, which is X. I can confirm that I've understood it.
That's great. I mean, there are all sorts of issues about how far that actually happens, for example, in the county court, where it doesn't seem to ever happen, and to do things like social security tribunals and things like that, where you often have people who don't have English as their first language, but that's a different issue. So I just wanted to say thank you so much to Charles and Miranda for what has been a really stimulating and thought-provoking hour. Thank you to all of you for asking such excellent questions, and we hope to see you soon and enjoy this somewhat bleak but bracing January day. Thank you very much.
Thank you very much, all.
Thank you, everyone.